Welcome back to AJS101, Introduction to Criminal Justice. This is Lesson 3, Part 4. Let's talk about the procedural defenses. But first, let's return to the lay of the land. We began by talking about the alibi defense, which was a defense of, I didn't do it, I'm innocent. We then spoke about justification defenses. And these are defenses where the person says, yes, I committed the crime, but I had a good reason for doing it, like self-defense or defense of others. Then we moved on to the excuse defenses. And these are defenses that said, yes, I committed the crime, and it was not for a good reason, but I should be excused from criminal liability because of something wrong about myself, maybe mental illness, or something about the situation, like provocation. So now we're going to move on to the next group of defenses, and these are the procedural defenses. Procedural defenses assert that the defendant did commit the crime, but should be relieved of criminal responsibility because of some procedural misdeed or error committed by a criminal justice system agent. The procedural defenses are entrapment, double jeopardy, selective prosecution, denial of speedy trial, prosecutorial misconduct, and police fraud. Let's talk about entrapment. The entrapment defense asserts that the police improperly or illegally induced the defendant to commit the crime. So entrapment involves unfair or excessive inducements that are capable of inducing a person not predisposed to commit a crime to do so. So, inducements are excessive or unfair when they, are excessive in number. The police keep hounding the same person. So an undercover cop thinks that somebody's a drug dealer and says, hey, will you sell me some drugs? And the person says no. Comes back an hour later. Hey, will you sell me some drugs? Person says no. Comes back the next day and the next day and the next day asking if the person will sell him drugs. Well, these are excessive inducements, and the fear is that the person does have drugs, maybe because he or she is a user, just to get you off their back, they'll sell you some drugs. So excessive would be an example of entrapment, excessive inducement. Inducements are unfair when they appeal to the defendant's sense of decency. Let's say that the defendant is somebody who uses drugs and has drugs, and an undercover cop comes up to him and says, hey man, I'm really strung out, I'm undergoing heroin withdrawal, I'm getting sick, I'm getting the bends, this is horrible, please help me, please sell me some drugs. Well, under those circumstances, that is an appeal to mercy. And if the person did sell drugs to the undercover cop, we don't know if it's because he's a criminal or he's just a nice guy or gal who felt sorry for the undercover cop, thinking that he or she was in withdrawal. So that offends the sense of decency. So that would be not guilty by reason of entrapment. Another example of entrapment would be if you offer unreasonable gain. So if the undercover cop dresses up in a fancy suit, rents a big limousine, and with a chauffeur pulls up on the street corner where drugs are sold and opens the window and says to a possible pusher, I say, my good man, I would like to try some crack cocaine. Would you be willing to sell me a vial for $500? Well, that's a situation where somebody who had crack cocaine on them but wasn't a drug dealer might be tempted for that outrageous profit to do so nonetheless. That is an excessive inducement, and that would be entrapment, and the person would not be guilty of selling drugs to the cop. Also, it's entrapment if the cop tricks the defendant into thinking an illegal act is legal. So if the cop says, oh yeah, you can do this, go right ahead, and then the person doesn't and locks them up, that would be entrapment also. An important point, denying one is a police officer when asked, or asking a person to commit a crime is not entrapment. So if I'm an undercover cop and I'm trying to buy drugs from somebody and they first say, "Are you a cop?" and I lie, which you would expect me to, I'm undercover, and say no, that is not entrapment. That's just police undercover work. If it was entrapment, police could never do undercover work because all criminals would always say, "Are you a cop?" to everybody and never get arrested. And you would have a hard time prosecuting victimless crimes like drug use, prostitution, gambling if the cops had to say they were cops when asked. And merely asking someone to commit a crime, a cop doing that, is not entrapment. It's only entrapment if the inducements are unfair or excessive. I mean, we did street drug buys all the time. I'd walk up to somebody and I'd say, "Hey man, I want to score some crack. You got any? I got $5. They sell you, lock them up. That's just good undercover police work. Only excessive and unfair inducements to commit crime would be entrapment. Double jeopardy. Double jeopardy is being tried twice for the same crime by the same sovereign. Now, sovereign is a legal term, and in the United States, there are 51 sovereigns. They're government entities. Each state is a sovereign. And who do you think the 51st sovereign is? The federal government. So if you're tried twice for the same crime by the same sovereign, it's entrapment. So if you're tried for, say, burglary and you're found not guilty, and then new evidence occurs, and the same state, or if it's the federal government wants to try you again, they can't. That would be double jeopardy. However, it's not double jeopardy if different sovereigns sue you. So if you robbed a bank that was insured by the Federal Deposit Insurance Corporation, well, that's the state crime of robbery, but it's also a federal crime to rob an FDIC-insured bank. The federal government could prosecute you, and if you were found not guilty, the state government could move in and prosecute you for the state law, and that would not be double jeopardy. So it's only double jeopardy when the same sovereign tries you twice. The federal government and each state, again, are sovereigns. So that's where that comes from. And it is the Sixth Amendment that prohibits double jeopardy. I'm sorry, the Fifth Amendment prohibits double jeopardy. Double jeopardy does not preclude criminal and civil lawsuits for the same act. So if you're found guilty of, if you beat somebody up, say, and you are acquitted, you're found not guilty of the assault, you could still be sued by that person for compensation for pain, suffering, and medical expenses and lost wages. So criminal and civil are two different things, and double jeopardy does not preclude criminal and civil lawsuits for the same act. Double jeopardy does not apply to mistrials and hung juries. If halfway through a trial, the judge says there was some major problem, jury members discovered facts they weren't supposed to, or what have you, that would be a mistrial. And a hung jury is when you can't get a unanimous verdict. To be found guilty, all 12 jurors have to find you guilty. To be found innocent, all 12 have to find you innocent. If even one in either situation does not do that, it is called a hung jury. And you can still have a second trial after a hung jury or after a mistrial. But double jeopardy does apply to the following: acquittals and dismissals by the judge for lack of evidence. Okay, now let's talk about selective prosecution. The selective prosecution defense alleges that a defendant was singled out for prosecution for unfair reasons. Maybe friendship. The mayor doesn't like you for some reason and gets cops to give you parking tickets. Or perhaps it could be your race, or some similar nefarious reason that other people were not prosecuted, but you were. The selective prosecution defense is based upon the 14th Amendment's guarantee of equal protection of the laws for all persons. We believe everyone should be treated fairly. Nobody should be singled out for preference or for prosecution. And the 14th Amendment gives us that under equal protection of the laws in the legal system. And selective prosecution clearly means somebody is not being treated equally. They're being targeted for bad reasons. Denial of speedy trial. The 6th Amendment guarantees the right to a speedy trial, which generally means within 60 to 90 days of arrest, minus delays caused by the defense. The clock stops or tolls if the defense is the one that asks for a postponement because they need to do more preparation or research. This defense prevents the state from unnecessarily keeping people in jail to await trial, because pretrial detention is a form of punishment, and it also might induce somebody to plead guilty who wouldn't otherwise because they're tired of being in jail. All right, prosecutorial misconduct. The defense of prosecutorial misconduct involves claims of unethical or even illegal conduct by the prosecutor, which harms the defendant's case or gives unfair advantage to the prosecutor. So examples of prosecutorial misconduct would include permitting false testimony to be given in court. This is an extreme breach of legal ethics, and a prosecutor could not only lose the case, they could be disbarred. Another example would be withholding information helpful to the defense. The prosecutor must give all the information that he or she has that they'll use in the trial or that suggests the innocence of the defendant, so the defense can use them or prepare to defend against them. Withholding that is also a serious misconduct by a prosecutor and could result in the case being dropped. And finally, unduly prejudicing the jury in court. If you were trying somebody and they had previously been convicted of child molestation, but that wasn't relevant to the current case, then that's not admissible. The jury can't find that out. If a prosecutor purposely let that slip during some questioning or during some summation, that would also be grounds for an acquittal based on prosecutorial misconduct. And finally, the police fraud defense. The police fraud defense involves the claiming that the police engaged in illegal behavior, such as fabricating evidence to get a conviction. This was a defense that was used in the O.J. Simpson murder trial, where the defense convinced the jury that the detectives had fabricated incriminating evidence against O.J., specifically a glove, which the prosecutors said was his, was involved in the crime, and the defense claimed was fabricated by the police. Thus, the famous line by O.J.'s defense attorney, "If the glove don't fit, you must acquit," as O.J. tried to demonstrate that it wasn't his glove because it wouldn't fit him. I guess you could have read that one either way if you were watching it. If you're too young for the O.J. case, go Google it or look on YouTube and you can get some interesting clips. It was quite the sensational case at the time being. So that's the end of Lesson 3. Hope you enjoyed it. I hope you study hard and do well on the Lesson 3 test. And I'll see you for Lesson 4.